Mr. Speaker.
Tracy Martin.
Kia ora, Mr. Speaker. Thank you very much. Before I begin my contribution on the Telecommunications Property Access and Other Matters Amendment Bill, can I just acknowledge, please, the Chamber support staff that are going to be finishing at the end of this week. This is likely to be the only contribution I give in this House this week, and so I want to acknowledge those that are leaving us, the time that they have given us, the care that they have given us over the years. We hope to see them again as friends, perhaps even occasionally at backbenches, and we can buy you a beer. So to move on to the Telecommunications Property Access and Other Matters Amendment Bill. Sir, New Zealand First will support this bill to Select Committee only at this stage. We have some concerns, and I think those concerns are based generally around the respect of property rights. And I think they've been the concerns that have been articulated and why it's actually taken the Minister the time to get to this point. Because there is a balance between moving forward with progress and at the same time being respectful of each individual's property rights in this sort of an area. I personally believe that the two-tiered system that the Minister has set up is a very positive one. I think that having Category 1, for example, installations that use existing equipment, aerial installations, installations that only disturb soft surfaces where those surfaces can be easily restored. I mean, these are reasonable, they sound reasonable, but again, we want to just say that we're going to support to Select Committee only because we want to hear from the public. I think an example, Mr. Parker has already referred to an example of cords, wires by chorus subcontractors or whoever being laid across gardens and so on. And one can't underestimate the passion that some people create in their gardens. And so therefore that may be a soft surface, but is it going to be able to be easily restored? And I think it's around making sure that we have a reasonable understanding around what those parameters are going to be. And the Minister has done a job on working around to make sure that those parameters are in place. The fact that we have a disputes resolution mechanism in here also it's a tried and true process. We've used it in other formats. It's going to now be placed inside this environment. Again, gives us some hope that this is something that will sort out this disorder. Category 2, the fact that installations are the width of the micro-trenching, it's not more than a prescribed width, installations are predominantly below the surface, like directional drilling. Those open trenching, those sort of things, that coming into that Category 2 area. And again, I think it is interesting, though, that what's the clauses that have actually been placed inside the bill, new section 155ZO, before recommending regulations prescribing a method of installation as a Category 1 under subsection 1E, the Minister must be satisfied that the installation will not have any lasting, substantial physical impact in the property. Now, one of the ways that we're going, that a person with those property rights is going to be able to protect them is the 5 working days for a Category 1, the 15 working days for a Category 2. So they're going to be able to actually lodge a complaint. Then no work, according to the information that we have at the moment through the regulatory impact statement and other documents, once a complaint is made, no work can be done on the property until it has been through the disputes resolution process. And then, if there's still no agreement, we understand that then it can actually go to the district court. So there's still that process of protection for property rights, and we're hopeful that it's going to be flexible enough and substantial enough to actually alleviate the fears of those people who are concerned about that. But we'll hear about that at Select Committee. I have no doubt that we'll hear about that at Select Committee. We are interested in what we believe to be a slight increase in the levy that's going to take place. It'll be interesting to hear the service providers' perspective on that, because I understand that there's an expectation that won't be passed on to onto the consumer. But we'll be listening to make sure that how that's going to impact on the consumer and how this bill's going to roll out. I just want to pick up on a couple of things that have already been said. I mean, I'll be interested. I'll be interested to have my peer that is sitting, Ria Bond, sitting on the Commerce Select Committee, because I understand that that is where this is going, I'll be interested in whether this might affect the right to occupy, and how, if that affects those that are sitting inside the villages and so on and have rights to occupy, as opposed to actually being on a cross lease or in a body corporate situation, may not touch them at all, But considering, Mr. Bishop, that actually everybody has the right to this technology, no matter where you live or what age you are, that is something that needs to be considered. And I pick up on Mr. Parker's conversation around the technologies that are available using ultra-fast broadband, and I think some of the advances in nanotechnology that may actually assist this nation to keep people in their homes for longer, thereby meaning that they are less of a financial burden in their old age inside institutions when they can stay in their home, if we can actually create these technological leaps. I also take a little bit of an issue with regard to Mr. Parker's conversation around copper and when is the moment to turn off the spend on copper. Doing a lot of work for the member for Northland around, in my portfolio area, around the delivery of broadband and internet up in Northland, with many of those people, being reliant upon copper. We would hope that until there has been a suitable solution for those communities, that nobody turns the tap off on upgrading the copper cabinets and actually doing the copper fibre blend that is being talked about and delivered possibly through North Power down power lines. And I think also that it's interesting, part of the reason I think that with regard to the contribution by the member from the Green Party around the delay, the delay for Chorus, for example, being able to get ultra-fast broadband into homes. Agreeably, the Minister pointed out that some of those delays are around this access issue, but there's also a massive delay with regard to Chorus, and there's a skill shortage, the inability of them to actually hire the number of people that they can then train to deliver this service. So we have some other areas of inflexibility there that we need to also address. And probably, so lastly, Sir, just to cap up, New Zealand First will actually support this to Select Committee at this stage. We'll be listening to the contributions of the submitters. The property rights, just the balance between property rights and access is the largest issue for us. As infill housing takes more and more, takes a larger and larger place, particularly inside of Auckland, as we go forward, this could become a larger and larger issue. We can appreciate that. There needs to be an answer, but it must be an answer that is balanced with the property rights of the existing population. Kia ora.
Kia ora.
Mr. Speaker.
Simon O'Connor.